Good morning, I'm Gary DeWaal, and this is Bridging the Weeks for July 25th to August 5th, and today is August 8th, 2016. The Commodity Futures Trading Commission again fined a Futures Commission merchant for not timely reconciling exchange fees and paying back customers that were charged too much, despite acknowledging the complexity and manual nature of dealing with exchange fees and discounts. Separately, CFTC staff again delayed the effective date of its own advisory requiring non-U.S. swap dealers that enter into swap transactions with other non-U.S. persons that are arranged, executed, or negotiated in the U.S. to comply with CFTC-mandated transaction-level requirements. Additionally, Eurex continues to roll out its ISA Direct clearing membership for clients, while CME Group still awaits CFTC approval for its equivalent direct funding participant clearing membership. Unfortunately, my dad passed away 2 weeks ago, so I did not produce a Bridging the Week last week. As a result, I have a lot to catch up on this week, so let's get started. Barclays Capital Inc. agreed to pay a fine of $800,000 to the CFTC to resolve charges that it failed to supervise its staff handling of exchange and clearing fees charged to customers from 2012 through 2014. According to the CFTC, after Barclays engaged an independent service provider to enhance its exchange fee reconciliation process in 2012, the provider in August 2012 identified that the firm had failed in July 2012 to pass along to its customers discounts to ordinary fees from one exchange for one exchange-traded product. Apparently afterwards, the firm accrued for overcharges to its customers, quote, but failed to timely pay out $1.1 million in exchange fee rebates with respect to the discount program for this particular exchange-traded product, end of quote. The CFTC claimed that during the relevant time period, quote, Barclays failed to implement and maintain adequate systems for reconciling invoices from exchange clearinghouses with the amount of fees actually charged to its customers through its back-office accounting software, end of quote. In agreeing to Barclays' offer of settlement, the CFTC acknowledged that by now the firm has provided refunds to all impacted customers and that its work with its independent service provider has improved the reliability of its reconciliation process. The CFTC also acknowledged the manual nature of complexity of the exchange fee process. This enforcement action is the CFTC's second enforcement action grounded on the theory that it is allegedly a violation of an FCM's general obligation to supervise accounts if an FCM fails to accurately reconcile exchange fees and ensure that customers are credited with overpayments on a timely basis. The first was a matter involving Merrill Lynch in 2014. Staff of the CFTC extended through September 30th, 2017, no action relief previously granted 5 times to non-U.S. swap dealers that transact over-the-counter swaps with non-U.S. persons that arrange, negotiate, or execute such transactions through personnel or agents located in the U.S. Under the release, such non-U.S. swap dealers are not required to comply with CFTC-mandated transaction-level requirements related to such swaps. In case you forgot, transaction-level requirements address mandatory clearing and swap processing, margining, and segregation for uncleared swaps, mandatory trade execution, swap trading relationship documentation, real-time reporting, trade confirmation, daily trading records, and external business conduct standards, among other matters. In November 2013, the CFTC issued an advisory which said that if a non-U.S. swap dealer regularly uses personnel or agents in the U.S. to arrange, negotiate, or execute swaps with non-U.S. persons, the non-U.S. swap dealer must comply with its transaction-level requirements. Goldman Sachs agreed to pay a fine of $36.3 million to resolve charges brought by the Board of Governors of the Federal Reserve System that it failed to maintain adequate policies and procedures to detect or prevent the unauthorized use and dissemination of confidential information of the Federal Reserve. This matter arose as a result of the illegal obtaining and use of confidential Federal Reserve information by Rohit Bansal, a former Goldman Sachs employee hired from the New York Federal Reserve Bank, that he obtained from Jason Gross, a former co-worker of Mr. Bansal's at the Fed. The Federal Reserve claimed that Mr. Bansal subsequently shared the confidential information with other Goldman Sachs employees, including Joseph Giampietro, a former managing director. Previously, Goldman Sachs agreed to pay a fine of $50 million to the New York State Department of Financial Services related to this matter, and Mr. Bonsall and Mr. Gross each pled guilty to criminal charges. Separately, the Fed filed charges against Mr. Giampietro related to his role in this matter through its administrative process. And finally, you will recall that a few weeks ago, CME Group filed proposed rule changes with the CFTC that would create a new category of clearing membership termed a direct funding participant. Under CME Group's proposal, a DFP could clear all its eligible proprietary CME Group trades directly with the CME clearinghouse, but would not be obligated to contribute to CME Group's guarantee fund or otherwise be responsible in case of a default by another clearing member. Instead, all of a DFP's obligation to CME Group would be guaranteed by at least one other clearing member, termed a DFP guarantor, that must also be a CME Group clearing member and be registered with the CFTC as a Futures Commission merchant. However, previously, this summer, Eurex rolled out its own version of DFP clearing membership called ISO Direct. Under this program, eligible insurance companies, financial institutions, pension funds, and investment funds domiciled in the European Union or Switzerland can become direct clearing members of Eurex Clearing without incurring obligations of the default of other clearing members. Instead, their membership is facilitated by an existing general clearing member, known as a clearing agent, that will not guarantee its client's performance, but will be responsible solely for what otherwise would be the ISO Direct member's default fund contribution and default management obligation. The ISO Direct member clearing agent could also provide transaction, cash, and collateral management services. Clients opting to become ISO Direct members would enhance their collateral protection through this program, claims Eurex, because they will have legal and beneficial ownership of all their collateral. ISO Direct members may ultimately carry their over-the-counter interest rate swaps, listed derivatives, and secured funding and financing positions directly through Eurex Clearing. However, for now, only OTC IRS interest rate swaps and repurchase transactions are currently available under the program. Although all these proposals clearly herald at least the partial disintermediation of futures brokers in some instances, they are worth studying. In the words of Bob Dylan, the times they are a-changin'. Well, that's it for this week's edition of Bridging the Weeks. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website, including an obituary for my dad. Check it out. I'm Gary DeWaal. Have a great week, and until next week, ciao.